Hello everyone, welcome to our YouTube channel Licit Capsule. Hope you all are doing well and healthy. Today we are going to talk about very controversial and hot topic in this ongoing pandemic, that is force majeure. So let's get started. First of all, what do you mean by force majeure? It is a clause in a contract wherein the parties under the contract have no contractual obligation on happening of such event which are unforeseeable in nature, such as natural disasters, including the coronavirus pandemic. Basically, a force majeure event is that when both the parties cannot control the happening of the specific event and it affects both the parties equally, making the obligation under the contract impossible to perform. There are three main essential elements for an event to be qualified as a force majeure. It should not be any party's default. It should make the execution of contractual obligation impossible to perform. It should have been unforeseeable. Force majeure clauses usually be found in various contracts such as power purchase agreements, supply contracts, manufacturing contracts, distribution agreements, and many more. The first and foremost question pops up in our mind that if the agreement does not contain force majeure clause, then what? The answer to this question is that if the agreement does not contain a force majeure clause, then the parties can rely on Section 56 read with Section 34 of the Indian Contract Act. According to Section 56, it relieves a party to perform its duty in an event where it is impossible to perform the obligation under the contract. So even if your contract does not contain FM clause, you can sought remedy under Section 56 read with Section 34 as mentioned in the Section 56 of the Indian Contract Act. The doctrine of frustration is envisaged, which evident from the word impossibility to perform the obligation under the contract. However, the party invoking the clause has the burden of proof to show that it took all the steps to mitigate the loss in such event. It further has to be quickly informed to the other party to the contract through a notice or as per the clause about invoking the force majeure. Since we are fighting against coronavirus and it has been declared as a pandemic by the World Health Organization on 11th March, and subsequently the government of India qualified the outbreak of coronavirus as a force majeure event in India on 11th March 2020. Interestingly, the government of India imposed the lockdown on 24th March to combat against novel coronavirus and thereby restricting all the economic activities throughout the country. Having said that, the Ministry of Home Affairs issued an advisory on 29th March 2020 wherein stated that it is a mandatory for all the employers to give salary wages to all the employees in the whole period of lockdown. This kind of statement was welcomed by majority of Indians since it will mitigate the hardship of the poor in the fight against coronavirus. However, the Supreme Court of India said that the said notification was contrary to Article 19(1)(g) of Constitution of India and it should not be mandatory for every employer to pay the salary or wages. Moreover, the notification is also contrary to the principle no work, no pay as enumerated in Article 39. Recently, the Supreme Court ordered in a petition filed by a Ficus Pax Private Limited and others who had managed to sort a favorable order wherein the Supreme Court stated no coercive action to be taken against company refusing to pay wages till end of July. If a worker is willing to do the work, then the wages are being payable as per the usual contract. The Supreme Court also directed the center to file an affidavit on legality of March 29th notification by the end of July 2020. Since COVID-19 does not discriminate between employer and employee, as both have been affected equally. The government has tried to maintain a balance of convenience from the above mentioned notification and had advised the employer to pay the full wages where the whole country is under lockdown and no activity has been done. Thereby, it is a move by the government of India to mitigate the hardship of the migrant labor, poor laborers, and daily wages. Henceforth, the employee must also recognize that the crisis may long last. Therefore, it is suggested that the employers and employees shall come forward to the negotiation table and adopt such measures that are beneficial for the society to mitigate the impact of COVID-19. To conclude, I would like to say that in this ongoing pandemic, where nobody knows when the situation will get better, therefore, the circumstances and the contractual construction of the force majeure clause plays a really vital role while invoking the same. It is convenient to have a force majeure clause in a contract rather than depending on the statutory provisions. I hope you find this video really insightful. Like, share, and subscribe. Please do comment below your thoughts. Until next time, peace out.